sometimes authors get lost in the idea of, maybe, oh, this is just a technicality and I can skip it, because in self-publishing, a lot of authors do. They skip this step, which I don't think is, me personally, I would never recommend. But what I wonder is if you happen to know the origin story of copyright, like why and how did copyright law come into being? Do you know that?
Mm, I do
Okay.
actually,
Yay. I'm
and
ready. Story
like
time.
most, like
Welcome to Pros Talking Pros, everybody. We are happy that you are here to join us this day. We are going to be chatting a little bit more technical than we usually do. Troy, you're going to need to keep yourself a little tame, a little less ranty.
I know. That's what I told Holly. I'm like, this is not going to be one of those days when it's like Troy's ranting. Instead, we have to keep things a little more
things a little bit more
civil,
tame and civil.
Yeah.
Because we are graced with the lovely Brad Fraser. I do have some words about Brad and I have had the pleasure of working together. At least it's been a pleasure on my part of working with together for a long time. Bradley is actually a lawyer that practices copyright and intellectual property law, correct? Right?
that is true.
He is a partner at Holly Troxel. He is a chair of the firm's intellectual property and internet practice group. Is that correct as well?
That is true.
Awesome. So if it lives online, carries a trademark, has a copyright, could spark a lawsuit, or you have questions about whether or not you don't know what your rights are with regard to that, Brad's your guy, and he's the guy I'm always telling people to check out. He's been practicing IP law since 1989. We're not going to age ourselves here at all, and has served as deputy general counsel for Fortune 1000 companies, and he's spent decades working at the intersection of technology, creativity, and ownership. He's actually an author, people. He's a novelist and screenwriter, so he understands our crazy quirks. And his debut novel was called The Cure. It explores the darker corners of human nature. And this is kind of a fun fact about Bradley that I did not know until today, which is funny, but he is the attorney who actually trademarked or registered the color blue for Boise. Is that correct? For the blue turf?
For the Boise State,
that is true.
The blue turf, the Smurf turf?
We obtained a registered trademark for the color blue for Boise State's turf. That is true.
So
that is fantastic.
So yeah, so he is the man behind the Smurf turf. So that's fantastic. So Boise native and Boise blue runs through his blood, so that's good. He's a Bradbury fan, which is Troy and I are also Ray Bradbury fans. So
yeah,
we love him.
If you ever get a chance in Chicago, go to the American Writers Museum. You can type on one of his typewriters.
Oh my! That's on my bucket list, Troy. Thank you.
Yeah, that's gonna have to be a good one.
Contact me. I'll give you directions. It's hard to find, but it's a cool little museum. Anyway, sorry.
That's fun.
Side quest.
Side quest with museums. Yeah.
Yeah.
So awesome. Well, there's what we're going to talk about today is kind of just the buzz surrounding some legal issues and Brad, I don't know if you know this about me, but I love copyright. Like, it's one of the things that I'm constantly pounding into my authors is this is very, very important. In fact, you should know a couple, was it last year sometime, Troy and I had a head-to-head where we discussed the importance of buying and registering your own ISBNs. And I was like, on the firm, you get your own ISBNs, you get your own copy, like, you do this because this is your IP. And Troy was on the other side. Well, you could use the free ones. And I was like, nope. And we had this.
Yeah, in some cases you can use the free ones. And then because of other things that have happened since then, and this is recording.
Yes,
I don't even want to say these words.
Say them.
She was right. She was right. Go ahead. You ready for your close-up? She was right. She was right.
Oh.
So I've changed my tactics
slightly
since then.
Yeah.
Yeah. Anyway.
So
Stacy was right. If you listen to the podcast regularly, just mark the date in your calendar and have a cake every year or something, whatever you need to do to make yourself feel better.
It was good.
Anyway.
But it was just because, it's true, right? Copyright is an important part of what we do, right? So, Brad, I want you to kind of first kind of tell me from a legal standpoint, do you feel like we might be in the Wild West when it comes to AI right now? How do you feel like the AI conditions out there are with you? And do you see a lot of this come across your desk lately with AI issues?
Thank you, Stacy, and thank you, Troy, for hosting me today. I've been looking forward to this experience, so thank you both very much. Yeah. The answer is, of course, yes. Every day I'll get a call from a client, and invariably there are some AI issues with respect to what that client has asked me. Mm-hmm. For example, just the other day, a client called who had developed a courseware program for helping elementary school teachers deal with the stress of being a teacher, which is very noble. Mm. And as we were discussing how she wanted to bring this product to market, it came up in conversation that she had used AI to create the content. And so, of course, as I'm sure we'll discuss in a bit more detail, she was disappointed to learn that she doesn't own any of those generative AI outputs. So her program that she has created using prompts and generative AI, she won't really own any sort of intellectual property rights in it, meaning that she won't really have a good remedy to stop someone from stealing and using it for free, which is sort of my mantra. My mantra is that an author wants to be able to own his or her copyrights because that's the only mechanism that we have to stop people from stealing and using our stuff for free. And if we are to monetize our outputs as authors, if that's our stock in trade, then we need to have a mechanism to stop people from stealing and using it for free. Copyright law is that thing. And the law has evolved currently such that AI outputs are immune or devoid of any sort of copyright protection. So yes, Stacy, that question comes up all the time because everyone is using AI and they're disappointed to learn that truth about the monetization aspects of their outputs.
Right.
Well, that brings me to a quick question. Can I interject? I know you have more of an agenda, Stacy, probably, but I have a quick question about that. There's a lot of talk about if a certain percentage, over a certain percentage is AI, it's not copyrightable. Is that, what do you know of that percentage? Like, is that a true statement or is this just internet rumor?
It's a great question, and I hear it all the time. So if I may, let's address it from where the rubber really meets the road, which is copyright litigation. Mm-hmm. Okay. The only way that an author has to stop the theft of their intellectual property, the only way is copyright litigation. You can send cease and desist letters. You can use DMCA copyright strikes. There are a ton of tools, but the only way to really make someone stop and pay you if they have used your intellectual property without permission is copyright litigation. Okay. So how do we get to that point? Well, when you create a product, whether it's a novel or a film or a clay sculpture, at that moment, as you both know, a copyright is created. Copyright is a noun, it's not a verb. Copyright is created when a sufficiently creative idea is reduced into or onto a tangible medium. That's the legal test. So copyrights exist all the time, right, without any sort of government action or any sort of percentage calculus. When a human being reduces a creative idea to a tangible medium, a copyright, a noun is created, period, full stop. Mm-hmm. Now, if that human being wants to stop someone from using that copyright without permission, here are the steps. One, they must obtain what's called a registered copyright. That's the law since 2019. So a copyright exists independent of registration. Creation, ownership, and registration are completely different constructs.
Right.
So once a human being has created a copyright, a human being then, to enforce that copyright, must go to the Copyright Office and seek to register the copyright. Now here, Todd, is the answer to your question. When you send in that work to be registered as a copyright, you are required to disclose to the Copyright Office how much of it was human authored and how much of it was authored by AI or a machine. It's up to you. And if you answer correctly, and most of the work, and there is no bright line test. The Copyright Office hasn't given us a percentage.
Yeah.
You simply have to make an ethical determination as to what percentage you feel you wrote and what percentage an AI came up with, and you declare that percentage in the copyright registration application. Okay. You then get a document, Troy, called a copyright registration certificate, and that's the ticket that gets you into federal court. The copyright registration certificate. On there, you will have disclosed how much is human authored and how much is AI authored. And during the course of the litigation, Troy, that's when we will determine how relevant that percentage is. So during that litigation, we will discover if a human being wrote 10% or if a human being wrote 90%. And everything falls from there. If the human being only wrote 10%, then 90% of it is not enforceable, and the case will probably be dismissed. If a human being wrote 90% of it, then most of it is enforceable. And Troy, the only person who determines whether something is copyrightable is not the Copyright Office, perhaps counterintuitively.
Oh.
It's not the Copyright Office. It's a federal court.
That makes sense.
So
Gotcha.
When you send in a copyright registration certificate and the Copyright Office responds to you because you want to go sue someone, Troy, and they say, no copyright registration for you. There's not enough human authorship. What does Troy do, Stacy? He files a lawsuit. He files a lawsuit against the Copyright Office. That's what Taylor did in Taylor versus Perlmutter.
Yeah,
that famous seminal case.
I remember reading about that. Okay.
That's why that case exists, because it's a federal court, Troy and Stacy, that determines copyrightability, not the Copyright Office. And so when you submit a copyright registration application, if you disagree with the Copyright Office, who has held that your work does not contain sufficient human authorship, your recourse is to simply file a lawsuit against the Copyright Office, just like Taylor versus Perlmutter and Taylor versus or Allen versus Perlmutter and on and on. There are several cases like this, right? But today, Stacey and Troy, we don't have any guidance from the United States Supreme Court on that specific issue. So we don't know whether or not AI outputs will have copyrightability because no federal court has declared it. There you go. Long answer, Troy, but that's the answer.
But then,
so in other words, there's no legal precedent that sets that we can say this is the legal precedent for that percentage.
I know that.
And also, I find it interesting that it's the author that discloses the percentage. So if you just tell them this is 100% human created, they believe you.
But they could be it could be disputed, correct? I mean, it could, if the Copyright Office wanted to challenge that, couldn't they?
They could, and they often do. There is a seminal, as we say, lawyers say, seminal Supreme Court decision called Feist. Feist versus Rural Telephone Cooperative, F-E-I-S-T. Feist is the seminal decision on this. Feist is the Supreme Court decision that determines how much human authorship is required for copyrightability. It's a very low threshold, but there has to be some human-generated creative spark to show that there's human authorship in that thing. Okay, so under the Feist decision, we are waiting for someone to determine whether or not something has sufficient authorship, even though an AI has generated it. So now to your question, Stacy and Troy, if the Copyright Office makes a determination that you have lied, frankly, on your copyright registration application, and you have asserted that it is human authorship, and for whatever reason, the Copyright Office determines that you have lied, they will, of course, deny your registration certificate, and now we can't go to court, right? So, but to your point, Troy, it's an excellent point. Many authors, whether they're acting disingenuously or they just don't know, will misstate the facts on a copyright registration application. They will conclude, yes, they will conclude that they have entered a prompt, and the prompt constitutes sufficient human authorship to merit copyright registration. That is untrue.
Okay.
A prompt alone is not copyrightable subject matter, and so there is insufficient one-to-one correspondence between a prompt and an output, at least under the current law, to merit copyright registration. So, Troy, to your point, many authors do exactly that. They put, well, I authored all this because I created all the prompts. That is incorrect, and in court, the wheels will come off that bus quickly.
Gotcha. And that's one of my main points when I'm talking to people who are pro authorship, AI authorship, when they're writing things, like books and everything. And I'm like, I understand that you feel that was your creation, but it ultimately isn't. In the case of Mel Robbins, like I said, with her, the let them theory, there are many that have come out and said that she's actually, there's some that have accused her of plagiarism, but I think it's because she probably used AI when she wrote that book, and it probably did pull from the generative AI probably pulled from some things that were out there. So it's quite interesting to see where this will land in courts when judges finally decide, oh, I'm going to make a decision here. but ultimately it's kind of an interesting atmosphere when you're working with a bunch of authors who are wanting to claim ownership of things that, like you said, Brad, that are not necessarily generated and can't legally hold water in the courts. To kind of take a side note, I mean, kind of lighten this up a little bit, because this is kind of one of those things I wanted to, I love the origin story of things. And I'm imagining that you are probably the same way because you're a storyteller, but the origin and the purpose of copyright is quite interesting to me, because I think that sometimes authors get lost in the idea of, maybe, oh, this is just a technicality and I can skip it, because in self-publishing, a lot of authors they skip this step, which I don't think is, me personally, I would never recommend. But what I wonder is if you happen to know the origin story of copyright, like why and how did copyright law come into being? Do you know that?
I do, actually.
Okay. Yay!
And
I'm ready. Story time.
like most foundational U.S. laws, it has its basis in the Constitution.
Right.
There is a provision in the Constitution called the authorship and inventorship clause, or something very close to that. And when they wrote the Constitution, the founders put a provision in there that said specifically that there shall be laws established to grant to authors and inventors, authors copyright, inventors patent, authors and inventors the exclusive right to their creations for a period of years, a period of time. That's it. That's they call it the copyright clause or the patent clause. And so it's constitutional in basis. And so as a function of that original constitutional pronouncement 260 years ago,
wow,
there have evolved laws over the years, most recently simply called the Copyright Act, found in 17 U.S.C. Section 101 and following, that vivifies the constitutional mandate to grant to authors the exclusive rights to their work product for a period of time. So there you go. It's completely constitutional. And the laws over the years have evolved to acknowledge, a thick book of laws, all derivative of that one clause. And even though you didn't ask this, I'll just add a little bit of additional color to
it.
Interestingly, just recently, the Solicitor General of the United States was called upon to provide briefing to the federal court to help it determine whether or not to grant copyright status to works of authorship by a machine. And so the Solicitor General began at that provision in the Constitution, and it says, to reserve to authors for a period of years the exclusive rights to their works of creation. Well, back when the Constitution was written, if you're an originalist like Scalia, you would conclude that when the word author was written in the Constitution, there were no machines. Author clearly has to mean human being. And so if you really want to get into it, Stacey, I would recommend that you find, or I can send you a link to the Solicitor General's brief.
I would love it.
They have gone through and pulled 30 different references from cases and statutes, clearly suggesting that when they say author in the copyright law, they mean human being, not machine. That's why I believe that the Supreme Court will not, the phrase that we use, and perhaps you've both heard this, grant cert.
Yeah.
That means that the Supreme Court will not take this case up, and they will simply allow the law to stand. The law today is that there is no human author, no authorship sufficient for copyrightability in machine outputs. And I believe the Supreme Court will let that stand because of these 30 different statements that are resident in U.S. law today, indicating that a human being must be the author, not a machine.
Yeah, I agree.
Right.
I agree.
I like that.
I feel that way too. And I've always loved that in that same constitutional statement, it's holding authors in the same caliber and I guess class as inventors. And I love that because I feel like creatively, as innovative humans, as we continue to push the boundaries of innovation, that authors are in the same, they're in the same, I guess, creative space as an inventor. In my opinion, I feel like that they help socially as we continue to push those boundaries and continue to innovate. I love it. I love it so much. It's one of those, it gives me warm fuzzies. So that's why I wanted to bring that up. Because
that's awesome.
I love that so much.
Me too, yeah.
Okay, can we pivot?
Yeah, let's pivot.
Ready to pivot? Because I want to pivot from AI because, I mean, we could talk about AI the whole time. But,
yeah, but no, but I love that just sets the standard. Like,
I mean, I just like that very clear legal standard.
Here it is.
So let's talk about Amazon for a minute.
Yeah.
And like their terms of service. There are a lot of people that say, you know, the KDP, the clause 5.5, the grant of rights that's in that terms of service pretty much just gives Amazon the right to do whatever they want. So like they've added AI tools to the Kindle that will answer inquiries about the book that you're in.
Well,
things like that. Like
Bradley, are you even aware of that recently that they added that AI feature?
Yeah.
I
was almost positive you would be, because if you haven't had several calls yet, I'll call you this afternoon. Then you'll have one.
Yeah.
But anyway, so my question is, in that grant of rights, like how comprehensive is that? Like how, for us as authors, like what do we have is there anything we can do? Is there any recourse within there as far as like, I mean, I know it would take some kind of giant lawsuit against Amazon and all their attorneys to do something, but like, what is that grant of rights? Does it actually grant them to add, you know, the ability to add those AI features
without permission of the author?
With our permission? Like,
you're very good, Troy, and you're right. It would require a large class action lawsuit by the harmed authors for Amazon to change that, because fundamentally, as a matter of contract law, that Section 5.5 and the rest of the KDP terms of service are enforceable as a contract. Sure, they are. Okay. And so if one author or a group of authors were to challenge that as being the term, as you perhaps both know, is called unconscionable, there's a provision in contract law that says when two parties have greatly disparate negotiating leverage, as here, greatly disparate negotiating leverage, then a certain provision can be set aside by a court as unconscionable, because the court will not allow one of the parties to have egregious control over the negotiation, just as Amazon does here. So sure, once you have clicked on the I agree button for KDP terms of service, you are bound by that provision, and they can certainly enforce it and do whatever they wish. Until, Troy, as you said, someone files a lawsuit against Amazon to have Section 5.5 or other provisions in the terms of service declared unconscionable because of the egregious disparity in negotiating power, then that will be the law. So what does that mean? Well, Amazon can basically do whatever they want with those uploads under Section 5.5. They can add AI tools, remove AI tools. But what's really interesting to me, as I read through 5.5,
I didn't see anything about
in there.
Yeah, I'm interested in what you have to say, because I didn't see anything in there. Like, I was like, okay, go on.
Well, what was interesting to me is that the terms of service contain certain warranties, and warranties, specifically warranties of title, meaning that Amazon causes the author to represent and warrant that it owns rights to the work product. But fundamentally, legally, that is not true if it was AI work product, for the reasons we've just discussed, right? So even though I know we're moving away from AI specifically, Troy, it is true that if your work product was generated by an AI and you upload it to KDP and you agree to the Amazon terms of service, you will technically be in breach of contract, because you cannot warrant that you actually own that thing. So it cuts both ways. Yes, the provision is enforceable and valid as a matter of contract law, But technically, if you don't own the rights to that thing, then you have violated the terms of service from the beginning, if you see my point. So it'll be interesting to see how this plays out and whether or not the authors do file some type of a class action lawsuit against Amazon, just as they did against Anthropic, as you know, the company that created the AI Claude, and there was a big class action lawsuit there.
Wow.
Oh,
which I think
really
is still,
interesting.
I think that is still being worked out in the courts, apparently, because there's a settlement. There was a settlement, right? But I know that the settlement's been challenged or something.
There's a group of authors that have broken from that settlement and said, reject the Anthropic settlement because we're going to file another suit.
Yeah, that's what I thought.
Because they feel like this suit was unfair in the stipulations of what were considered stolen works. And anyway, things like that. So there's a whole bunch around that. What I'm curious about, so if by uploading AI generated material, you're actually violating the terms of service. So Amazon has that little checkbox, was AI used in the generation of your stuff, as you add now.
Yeah.
My question is, if Amazon is then adding AI features into the Kindle that impact your work, like how does that cut the other way? Like does it cut the other way, or do they just have those rights under 5.5?
Well, 5.5, I mean, tell me if I'm wrong, Brad, but I didn't even see anything in 5.5 that actually had anything to do with adding those tools. That was like specifically in the terms of service and how they were how they were granted the use of your IP when it comes to publishing it and distributing it to their users. But in that clause, I didn't see any way that they could then insert the like, I figured that the AI insertion and using those other tools on those specific apps would probably have to exist in another clause, because this clause specifically didn't even address that issue. Am I right? Am I wrong?
No. I think throughout the rest of the terms of service, they'll find the provisions that Troy mentions that give Amazon liberal control over your manuscript to add AI tools or modify it or vary it or create derivative works or whatever they wish to do. But what is the impact on the author of these provisions in the KDP terms of service? Well, as you both perhaps know, one of my favorite sayings is, it's all academic until you get sued. And that's true.
It's totally true.
When a client, if a client were to call me and say that someone has taken my KDP book and they have made a screenplay or a stage play, or they have changed the cover, the cover page or the cover art or something, and taken my work and styled it or positioned it as their own, either on Kindle or someplace else out on the internet. Okay. The questions I would ask them are, one, do you own a copyright in that work?
Right.
It all begins with, do you own a copyright?
Right.
And then we ask all the questions derivative of that. Second, you have a registered copyright. And if you don't, there's nothing I can do to help you, because registration is now condition precedent, as we say, to filing that copyright infringement lawsuit.
Thank you, Ruth Ginsburg.
Right.
Yeah.
Third,
yes.
Third, are there any sort of legal entanglements or impediments that affect one or two?
Right.
Right. And the answer here is yes. You've agreed to the KDP contract. So in order to fully analyze the client's rights under copyright law with respect to that infringed work, we begin with, do you own a copyright? Two, do you have a registered copyright? Three, and there are other things besides the Amazon contract that may affect that. For example, did you create the work during the course and scope of your employment? If so, then you don't own the copyright. Your employer does.
Your employer does.
Yeah, I remember that.
The work for hire doctrine. Have you signed any sort of a contract as an independent contractor, assigning the rights to the book away? And so once we've gone through that litany of analysis relative to ownership, registration, and the overarching legal structure, then we can really analyze whether or not they have any rights. So you see, much of this remains academic until the client says, I wish to stop someone from stealing my stuff. And all of these things, Troy and Stacey, will affect that client's ability to stop someone from using their stuff. They may simply not have the rights. They may have contractually given those rights to Amazon.
Yeah. Yeah.
So this has raised a really interesting dilemma in that if you have if you've uploaded AI generated stuff, so you violated the terms of service, then even if Amazon violates the terms of service in return,
the contract was already
like you
null.
don't have the contract was already void, right? So if you're uploading AI created material, you're extremely vulnerable, I would think, legal on a legal standpoint to someone infringing upon your work and you having no legal recourse. Is that
Exclamation point.
Right.
I mean, no, I was putting a question mark, but exclamation point is good too,
Exclamation.
because I'm trying to reason this through, like for coming to conclusion, because I'm fascinated by this, because like I'm one of those people, I'm like, if you want to draft your book with AI, as long as you edit it to human, you edit the crap out of it basically to human standards, so you have a ton of human input, that's wonderful. If you're just publishing AI generated stuff, then I'm kind of like, I have some questions about whether you really want to be an author or you're a business person creating a product that's consumable. I think that's two different things, but because I love the drafting process, that's why I do this whole thing
Well,
anyway.
writers should want to write.
But I'm just like, that opens up a whole legal thing of like, I mean, I wonder if Amazon's having you check that box because they know that. They're like, ooh, we could make a movie out of this. There's nothing they can do about it. I mean,
well, probably.
They had a smaller attorney.
That's probably exactly why they do that, right? I mean, they're Amazon, and so that's probably exactly why they do that.
Mm-hmm.
That's interesting. Because they definitely don't have our best interest at heart. I mean, we know that, going in. Unfortunately, it's exactly like you say, they have the leverage of, 80% of our income is coming from Amazon. So I can not agree to the terms of service and not publish with them, or or I can publish with them and just take all the things that come with it. Right.
Exactly.
Right. There's an ancillary point here. I have seen a number of clients come to me with contracts for, and you'll forgive me, Stacy and Troy, I don't know the less pejorative term other than vanity press. What's the better way to describe it?
Let's call
it vanity press, because the other terms that I would call it, then Sydney's going to have to bleep those out on the podcast. So, we'll just call it vanity press.
Yeah.
I'm glad we feel the same way about that. I have been approached by a number of clients, many of whom are, bless their hearts, senior, who have been on social media, and you've seen the advertisements. Do you want to publish your memoirs? Do you want to tell your story? Click here and work with, Freeport Press. I just made that up. I don't remember any of the names. And so typically they'll charge, as you both know, I've seen anywhere from $15,000 to $50,000 in vanity press fees to print your book for you. Well, a number of those authors have been told that they will own the copyright in those books. And that is not true because, as you know, the vanity press now has found that the way to really, really expedite their workflow and their outputs is to use AI to generate the books. And so they're very brazen about it. I've seen a number of terms of service and contracts from vanity press that say, you will own your book. That's simply not true. So I've seen, and I have to disappoint a number of authors who are excited to tell their life story to learn that they won't own the copyright in their book because the vanity press uses AI. Isn't that interesting?
Yes, because there's a whole industry I've seen ads for of AI ghostwriting. Oh, you can just replace all your income by using these tools and AI ghostwriting books for people. And I'm like, as a ghostwriter too, I'm like horrified, number one, because I don't know what their output even looks like. But also now to bring this up, like this has been fascinating just because of the ownership aspect of AI. I'm like, you can't even register the copyright unless you're lying.
Yeah.
Unless you straight up lie about it.
Right.
Exactly. So business owners
Troy.
So business owners and entrepreneurs who are wanting to write those books, and they're like, okay, I want to, have this expensive calling, business card that says I've created this.
I wrote a book.
If they're using the AI to do that, that is just killing them. That is shooting them in the foot. I wonder how many of those AI or how many of those presses, like, I know that probably Forbes probably isn't, but there's a couple of presses out there that Troy and I've been looking into specifically with ghostwriting options for for business owners. I wonder how many of them actually are switching to AI, because I know a couple of editors who are also ghostwriters and book doctors, and they've been out of business. They've been put out of business lately because people are like, oh, we're just going to use AI. But knowing this about copyright, it really kind of puts a kink in the whole hose, doesn't it?
Well, and also, I mean, the output from AI is just, no matter how you slice it, is inferior without human intervention. And once you add the human intervention, it's no longer AI. AI is just giving you a framework or an outline or something to work with. But I have never, I have played around with all the tools, and I've never had something where I could take the AI output and go, yep, that's the book. And there has been nothing that's been that way.
Is that
has to do with the legal aspect, but I mean, man alive.
Is this holding water and across the board from written word to video production as well? Because we're seeing a lot of video production right now being done in AI for, even just short films, but as all the YouTube videos that are uploaded and put up by people. I mean, I'm assuming that the copyright law holds for that as well. It's the same thing.
That's right, Stacy. It's exactly the same. And so I wanted to ask you and Troy your thought on this specific question. Do your clients care about this? And the answer, you're thinking, well, of course they care. But do they? Because many times, at least my clients, are so anxious to have a book in print and to be able to say, I'm a published author. They don't really seem to either care about or fully understand the downstream consequences of not owning that copyright.
I think that's
because, quite frankly, with millions and millions of published books out there, just between the three of us, what really are the odds that someone's book, Amazon published AI book, is going to be copied and stolen by some bad actor, third party? Pretty low. So, I mean, legally, everything we discussed is correct. But what do you both think about the practical realities? Do people care about this?
Well, I would say that, well, I'll say first, I would say that yes, they do, once they understand the ramifications. And I think that's one of the main reasons why I do what I do is I, educate those authors fully and give them I show them the Wizard of Oz behind the curtain and all his nakedness, right? Like the emperor's got no clothes on. Here he is. So that's kind of like my whole reveal on the publishing world. And that was one of the things that I always pointed out long before AI came along, is this whole reveal about that you ultimately need to hold to your copyright and your IP, because this is your brain and this is your creation, right? Once I explain that and what those long-term, like you said, those long-term down the road ramifications are of like choosing the free ISBN versus not, and going with the hybrid publisher or the vanity publisher or not, and those kinds of decisions, they do make a difference. And we are kind of seeing kind of an interesting kind of like revolution happening as these small presses are going out of business. We're seeing all these publishers or published authors coming to us and going, okay, how do I now self-publish? And when I put it to them, like, you need to have an ISBN, and explain to them that the reason that the publisher was making the money is because the publisher had that ISBN in place, and asking them, did they register your copyright? And them going, no. And then, some even authors going, well, I thought I would have some recourse for this Anthropic because 7 of my books were stolen. And then the first question I asked them is, did you register your copyright? Because the judge has set this precedent. You have to own your ISBNs and you have to have registered your copyright. And did you do either of those things? Well, no, my publisher said, and nope. Ignorance of the law doesn't mean that you're void of following those, right?
Because it used to be a part of your publisher's contract that they would register your copyright, but many publishers have taken that out or made it an optional clause in their contracts. But I think, to the answer to your question is, I think there's two camps. I think there are the people that care, and people that think they don't care, do care once you educate them. But some people, even once you educate them, they go, I don't care. I just want my book to be out there in the world.
I'm going to liken those people to brainwashed cult followers.
Well, in some ways, but here's what it is they bought into this lie and they fail to understand. We've got millions of books published on Amazon every year. And I always tell authors that are doing it professionally, they are not your competition.
Right.
They're not doing anything to market their books. They're not doing anything to make their books more visible. They're not doing anything about their visibility online. Those people are throwing books out with a hope and a prayer, and you don't pay the rent with a hope and a prayer. It doesn't work that way. Back up your truck of thoughts and prayers, dump them on my lawn, but I need some money.
Right.
Is kind of the way things go, right? So we know that doesn't work, but there are people that still hold fast to. I mean, I had a guy that called me just this last week, and it was an astounding phone call, because by the end of the phone call, he had completely reversed his thought process, because he thought he was just going to throw this book out there and it was going to be a Hugo Award winner, a New York Times bestseller. And I'm like, so what's your marketing plan look like? And it was like, no clue. And then it was clear that his cover was generated with either the KDP cover generator, or he'd had AI do it or something. It was terrible. It was a terrible cover. I'm like, this is not going to work in the marketplace. And he was instantly like, oh, well, I guess I have to rethink everything I was thinking about. And I'm like, you have it costs money to bring every single book to market, and you have to pay that money to even get it to the market before you start marketing it. And I think with some of them, it's a complete lack of understanding, but some of them, like as soon as I've been telling him that, he's super discouraged. Well, I'm on Social Security. I don't have a lot of money. I'm like, well, you probably called the wrong guy. I have to charge you for things. You know what I mean? Like, it'd be like somebody calling you and saying, hey, Brad, handle this lawsuit for me, or, something that like, you're like, I don't know how I'm getting paid for that. Like, I don't think I'm going to handle that for you.
Yeah.
Unless
Sorry,
you
all
got some money.
my pro bono calendar's
My
already
pro
booked.
bono calendar is already full, that type of thing. And I mean, that's kind of what I have to say now with a lot of people, is like, hey, sorry, my pro bono calendar is full and overfull.
Yeah.
So I think that's the answer to your question, is there's both camps of people that care and people that don't care. But the people that don't care are not publishing professionally. They're not the ones that we as authors and publishers are really concerned with. They're not my competition.
Well, I will say,
and they're not even really my colleagues either.
Yeah,
they're in this fringe state over on the side.
I will say that we're seeing quite a bit. There is quite a movement, and there's also this anti-AI camp that's also causing a lot of discontent and hate out there. But so there is, I always say that we strike a healthy balance with this new tool that we've been shown. And again, use it wisely, but not in a way that, like you said, that would infringe upon our rights as we go forward. And of course, take away the creative, amazing spark that we generate out of this process that we call writing, right? We don't want to take away the love that we have for this, what we're doing here. And AI seems to suck the love out of it, all over the place. But my whole thing is that seeing these people that are pro AI, that are creating these tools, that are they own these companies that are generating these books, that are like trying to shorten and make this process of writing easier. It feels like they're the ones that fuel that, well, it doesn't matter camp. And like you said, it's like, but once you sit down with an author one-on-one and educate them, it does feel like that more and more of them understand and realize, wait, there is a reason why this has been established.
Yeah, it is. I mean, there's kind of the Anthropic lawsuit was a big wake-up call for people, I think, because a lot of people hadn't registered their copyrights and they hadn't gotten their own ISBNs. And so they're seeing those books on that list and they're saying, that's $3,000 a book. I lost $21,000 because I didn't spend, $300 on copyrights, per book or whatever. So I'm losing $21,000 because I didn't spend, $200. And so it's a wake-up call of them to say, okay, yeah, I do have copyright. Copyright exists, as you said, as a noun as soon as I finish my book. But since I didn't register it, now I have no recourse in court. And so a lot of them are scrambling like, okay. And then a lot of them found out that publishers had made that registering copyright an option in their contract, and so had not registered. So Harlequin, that's why a bunch of them are up in arms about rejecting the Anthropic lawsuit, is they're saying, hey, this wasn't my fault. My publisher didn't register my copyright. they're kind of pleading an ignorance type, thing of I didn't know what was in the contract, which is kind of doesn't really matter if they're ignorant of it or not. They signed it anyway. But of course, those are the people that they want a traditional deal so bad. They sign the contract and they don't look at it. They don't read it. As a publisher, I've sent people contracts that come back in 5 minutes, and I'm like, you didn't read the contract.
Read it.
I could put anything in there.
Yeah. Even in our publishing contract with Alibi Syndicate, it was funny. Like when I got 2 of our authors that just sent them back without even, I was within 5 minutes, and I'm like, there's no way that you took this to an attorney and had them read this. Like, there's no way. And it's advice I give every one of my authors, like, take my contract, take it over to an attorney and have them read it, because it's not just about me here, it's about you. And as much as I'm trying to protect you in my own contract, I'm in good faith doing that, but at the same time, you have to take care of yourself here. You have to watch out for yourself. And so that's another reason why I'm going to say, if you don't know who to call Brad Fraser, because he knows. True. But going forward, Brad, do you think we're heading for some more, I guess, clearer AI legislation? Do you feel like that we're heading that way with these? Because Google right now is in a litigation, I guess they're being sued regarding some AI theft. And I'm just wondering, do you think that this is just going to be a years of messy court battles, or do you think that we're going to start seeing some judges make some rulings here that are going to set some precedents? What do you think?
Right. Well, as you perhaps know, Stacy and Troy, I view it as having an inbound aspect and an outbound aspect. Here's what I mean by that. From an inbound aspect, we have the fact that for today, most LLMs, large language models, are still trained by going out and scraping content off the internet for free. Most. There have been some inroads, just as with the Anthropic settlement, there have been some inroads by which LLMs and AI companies are paying to scrape that training data. And those are called, as you know, known good data sets. Right. And so a business model has sprung up where third parties are allowing known good data to be scraped to train the LLM. But until then, we have the inbound issue of copyright infringement from the beginning. Copyright infringement because training data is being scraped without permission. Downstream from that follow a whole host of legal issues, principally because we don't know how and where the LLM was trained. We don't know how good the outputs are, and this is why we have hallucinations.
Right.
And so I encourage my clients to think beyond copyright and ask the question, if you use an AI to generate this output, can you, for example, warrant that the output is accurate? No. Can you warrant that the output will not cause you to be sued for defamation or a right of publicity violation or copyright infringement? No, because you don't receive those protections from the AI vendor, right, which, as you know, is called indemnification. So we right. have the whole host of the inbound issues. What will solve that, Stacy, is, I think, additional licensing of known good data. If all LLMs are trained going forward on known good data, that will lessen both the copyright and the warranty and the defamation and the other problems that follow downstream from having AI outputs. Okay, that's the inbound side. The outbound side, we've done a good job discussing today.
Right.
The outbound side is that there's no ownership in AI outputs. Will that change? My belief is no. I don't believe the Supreme Court of the United States will hold, overruling 260 years of copyright law, the machine has human authorship characteristics. So there you go. That's my view on the inbound issues, fair licensing. The outbound issues will persist, meaning that I don't believe that humans will own copyrights in AI output anytime soon. I don't.
Yeah.
That brings up one more question. Can I ask one more, Stacy? Can I?
Yeah, go ahead.
So on the inbound end, so really the Anthropic lawsuit was more about where and how they obtained the works that they trained on rather than the training itself. What do you feel about the claims that the training is fair use?
Wow. You know, Troy, what a great question. And here's how I see it as a copyright lawyer. The copyright law has a specific provision at 17 USC section 106.
Yeah.
To me, all roads lead to 106. 106 is the statute that gives the human being author exclusive rights to the work upon fixation. Those rights are automatic upon fixation, 106. Okay. 106 grants to the author, the human being author who did the fixation, the exclusive right to reproduce the work, to create derivative works, to publicly deform, publicly perform, publicly display, and distribute. Those are the 106 rights.
Right.
Okay. So 106 says reproduce. There is no equivocation that the initial training, the scrape, is a 106 reproduction. And many of the AI companies choose to use terms like training or memorization or learning, but those aren't in the statute. The statute says reproduction. And by definition, when the LLM scrapes that data, a copy is being made ephemerally in computer memory. That violates section 106, period. No court has held otherwise. That's the law today. Now, to your question, that initial scrape, Troy, is not a fair use. It can't be. It violates 106. But what happens downstream from that is probably sufficiently transformative to be a fair use under the most recent Supreme Court decision, which is called the Warhol case. So my deeply held belief is that it's two steps: scrape and transform, scrape and transform, scrape and transform.
Gotcha.
The scrape, the scrape violates 106, period.
Mm-hmm.
No court has held otherwise. So until, Troy, a court holds that the original scrape, which is a reproduction under 106, is a fair use, it's not. And everybody who does it is committing copyright infringement. There you go. That's my soapbox.
Yep.
Oh,
And period.
I love that soapbox. Because I'm like,
too.
yeah, it is fair use for you to learn from my book. Like if I put out a book, a nonfiction book, and you learn something from it, that's fair use, absolutely. But if a college professor steals 30 copies of my books and gives it to their students to learn from, the stealing of the book is the illegal part, not the students learning from it. Right? Is that an equivalent?
Sure. And let's talk just briefly about this notion of learning. I'm asked all the time, well, isn't it true that I can buy a book and I read it and I'm creating an ephemeral copy in my brain? Isn't that the same thing as training an LLM? And the answer is no.
No.
The reason is because the law has not held that reading a book is reproduction under 106. That's the simple answer. Whereas there are many cases, Troy, that hold that training a computer on a copy is 106 reproduction. That's the difference. I don't have a better answer. The law does not hold that reading a book, even though you may say, well, I'm learning from the book. How come that's not copyright infringement? Well, the answer is because no court has held so. That's it. There is no better answer today. So,
gotcha.
Okay. Right.
I love the legal answer of that instead of my.
It's just clear.
my I can learn from something.
Yeah.
But I mean, I am not making a copy in my brain, because I can guarantee you in my brain that would be an imperfect copy.
And that's and that's what a lot
very imperfect.
A lot of AI company runners and owners that I've talked to, even in our world, Troy, they lean on that. They say, well, it's fair use. We can, and yeah, I've always felt the way Brad said. No, wait, I could never believe the scrape does not make sense. Like, yeah, it's not legal. It's sorry.
Well, and so here's the thing: like, what it does, it opens up an opportunity for authors and publishers, though, because you can add your works to a known data set.
Yes, you can.
Right? A known, reliable data set for a fee, and then they bought the work from you.
Right.
So then they certainly may learn from it instead of scraping it off the internet. They bought it from me. So now, yeah, go ahead and learn from it.
Well, it's like when it's like when a library buys your rights to, distribute your book in the library. They pay a little bit more because they're, going to distribute it to a larger population or a larger set of eyes. And so therefore they're paying more to access those rights. It's kind of like when you buy, music licenses, you can buy it for your personal use, but if you want to use it for a public, event, you pay much more
Yeah.
For that
Right.
license to use it. Yeah. So it's all
Right.
about licensing, I think, in this
Yeah.
case. But
When I perform my public dance routines, I need to license
yeah. So
right.
Right.
Brad, you're an author yourself, and I can only imagine what you're gonna say about this. But like, what would you tell an author that does say that says, I don't care. What is your thought on that? How do you feel about that?
I would probably say to them, as I have other clients, well, that's fine. But know, though, that if you take the position that you do not wish to own any intellectual property rights in this output, specifically copyright, let's consider the downstream consequences of that. Number one, you won't have anything to bequeath or devise to your children. A copyright is inherently divisible, meaning you can inherently put a copyright into an estate plan, and your children and grandchildren will own a copyright. If you're willing to not have that luxury, okay, it seems like that's a little short-sighted, though, because it seems like you would want to have a legacy. You see how compelling that might be for a certain demographic, right?
Right.
You want to have a legacy to give to your grandchildren or your children or your university. You maybe want to bequeath these things or gift them to a university or to your children. You cannot if an AI wrote them. Consider that.
Yeah.
Number two, remember that when you see someone who has made wholesale free use of your work product, and maybe you never will, maybe you're going to be that, but maybe you are going to be that unicorn whose work is copied, whose work does become famous. And wouldn't you be aggrieved to know that you have no recourse against someone copying what you believe to be your work product and stopping that act of infringement and monetizing it? Right? I would say, what is your goal with respect to this work? If you have a completely open source mindset and you have no desire to monetize this, then Godspeed, right? But if you do have a desire to monetize these outputs, there is no way forward other than to use human authorship, not AI. So Stacy, those are some of the things that I think about when I advise clients about the consequences of choosing to use AI over human authorship.
Right. I felt I had a feeling that you would say that. But yeah, as a publisher, I know that Troy and I have like taken the stance of like it's okay again if you want to say that this is your AI generated manuscript, but there will be a different way that we go about publishing that as opposed to, like you said,
right.
setting
Well,
those.
yeah, as a publisher, from a publisher standpoint, you can't take the risk because of exactly what you talked about. Somebody else can copy the work, sell 1 million copies of it, and our recourse is to say, dang, I wish we'd done that.
Yeah. Yeah.
I wish we'd been able to sell 1 million copies of it, but we really, for the author and for us as publishers, we would have zero recourse in a court of law. And that's kind of frightening to me. And I love what you said about legacy as well, because I hadn't thought about that aspect of it necessarily, even though I had thought about the legacy aspect, but I hadn't thought about the fact that if you can't copyright it, you can't leave it to your heirs.
Right.
So,
sorry about
correct.
this.
Yeah.
So I have one last question before we let you go. Are you ready for this?
I'm ready.
If authors could understand one thing, if you could leave one last like word of wisdom for them here regarding AI or intellectual property as a whole, like what would you want those authors to know and understand going forward in this like kind of age of quickly getting things out there and published?
Right.
Yeah.
I think I would, in addition to my two mantras, copyright is a noun, and it's all academic until you get sued. I would say that copyrights are a trillion dollar driver of our economy. If you think about it, think about every film, every song, every Taylor Swift, everything, every bit of sculpture, every bit of art, every T-shirt design, everything, every photograph, all of that is a $1 trillion driver of our economy. It really is.
Yeah.
And if suddenly, overnight, if the ability to stop people from stealing and use that content for free went away, effectively, if copyright law went away, then what would the consequences to our economy be? That would be $1 trillion hit to our economy, because there's no way for Pixar or Disney or whomever to truly protect against the theft, the wholesale misappropriation of those things, Stacy, and thus there's no way to monetize them. So I think my takeaway would be, remember, the space in which you're working, copyright, is $1 trillion economic driver. It really is.
Wow. Yeah. That's amazing. I didn't even think about that, but yeah, just it would launch us into a zombie apocalypse.
Pretty much.
Yeah. Yeah.
Yeah. Well, awesome. Thank you so much, Bradley. I mean, like, the wealth of information in your brain, honestly. Bradley has taught at a couple conferences we've been involved with, Troy, and it's just been a real pleasure to have Bradley in our valley. But if you want to have access to him, you can certainly contact him. I know I have several clients that work with Bradley that have not necessarily worked with him in the state of Idaho. You can be anywhere in the country, right? And contact Bradley. So
that is right. Copyright law is federal in nature. So I do have clients in actually most of the 50 states, actually. So yeah.
Yeah.
Wow.
So,
fantastic.
And he's a wonderful, wonderful human. And like I said, he understands your weirdness. So go ahead and give him a call, because he gets the weirdness of authors. He gets it. I really appreciate you being with us, Bradley. I really appreciate. How would people get a hold of you if they need to get a hold of you? Can you let them know?
Well, in my training deck on AI, I have a slide that has my contact information. So, but since we don't have that deck in front of us today, I would say, I think you probably know how to reach out to Stacy, and she knows how to contact me. But I'm also pretty visible on LinkedIn and on the internet. So my advice, as humbly as I can say it, would be, I would say just Google Brad Fraser, Frazer. There's no I in there, or Bradley, Bradlee, Fraser. A couple of Google searches. I think you'll find me at my law firm in Boise, Idaho, which is called Hawley, Hawley, Troxell, Troxell. And I would look forward to visiting with you.
Awesome. Well, and tell him where you found us.
tell
him that's Stacy and Troy. They told me to call you, and then he'll know how weird you really are.
Absolutely.
Well, I really appreciate it, Bradley. I hope you have a wonderful week. And if there's anything that you ever need from either of us, just reach out and let us know. But
thank you so much, Troy. A real pleasure today. Thank you, Stacy. Always great to see you. And thank you both for what you do for the artists and creatives out there. And you both provide a super good resource. So thank you both. And please have a great afternoon.
Oh, you too.
Thank you.
Again.
You too.
See you later.
See you later.
Bye-bye.
Bye-bye.